Yes, good morning.
Good morning.
I am Hugh Umstead. I'm co-counsel Mr. Ted Caratinos, representing Joseph Comazzi as the personal representative of the estate of Mary Funke. Mr. Jack Hoagland is here also on behalf of the Appellate. Your Honors, we're asking the court to reverse the judgment where a guardian, as officer of the court, misrepresents to the court that the ward had no will in a series of pre-death petitions to distribute that ward's assets. After a two-day non-jury trial, the court rendered basically a one-sentence judgment. There were no findings of fact. Now, the standard of review is not quite de novo. It's kind of a hybrid of that. I think the citations in our standard of review are correct. Fundamentally, it's here when the trial court makes no findings of fact, this court must determine, based on the record, whether proper analysis was given to produce the result that the trial court received. Also important is the burden of proof. I point out to the court that the burden of proof, it's our position, is cited in the Bacon case at the trial level, was preponderance or greater weight of the evidence. There was a discussion about that with the court at the conclusion of the trial. I would refer you to the record page 1016. And in that, the courts asked me, before you rebut, let me ask you a question.
Your Honor, I realize objections usually are permitted in oral argument, but
yeah, you'll have a chance.
Okay, I'm just saying this was the burden of proof was not an issue.
Well, please.
Yes, sir.
Okay. Before you rebut, let me ask you a question. What's the standard? What's the burden of proof for extrinsic fraud? Counsel replied, generally it's preponderance. I saw a standard review out there at some point that was, the court says, generally for fraud, it's not preponderance. Mr. Umstead, yes, or no, it's by the greater weight, I think is the correct term. Mr. Hoagland states that the case law I'm familiar with, Your Honor, is fraud has to be proved by clear and convincing evidence, whereupon I said, replied to the court, extrinsic fraud, Judge, I believe, is preponderance. So I just point that out to the court. There was no identification of what the standard was borne by the trial court in reaching its conclusion in its judgment. Candor before the court is of paramount importance. I think there are some trial judges on this panel, and I think everybody understands that candor to the court in all circumstances is critical. We have issues where we might, we're advocates and that sort of thing, but I will point out during my discussion here that Ms. Kessler was asked directly by Judge Glisson at one point, is there a will? And she replied to the negative. Now, why is that important? The court, I'm sure, is familiar with the facts. Basically, we're talking about a time frame from September 1st of 1992, when Lord Kessler was appointed as guardian, till the ward died. Ms. Funke died on September 28th of 1996. So 1992 to 1996 is a time frame in which we're interested. During that time, Ms. Kessler filed 4 petitions with the court and asked that distribution of the ward's assets be distributed. Now, the court wants to know, what's the extrinsic fraud? Why is it intrinsic? How is it extrinsic? It's extrinsic in 2 ways, Your Honor. One is that the court did not have all the information that it would require to put herself in the shoes of Mary Funke, who was incompetent. And why is that important? Well, as a trial court judge, if, let's say, for instance, the facts changed a little, Ms. Kessler responds, Judge Glisson, or in the petition said there's a will out there, it may be invalid, here's what happened in the trial court, in the Supreme Court in Nevada, but there's a will out there. What does the judge do? Much like in Bohop, most judges would appoint a guardian ad litem. They would inquire. There's a will. Okay, what we're going to do now is going to appoint a guardian ad litem, or you, counsel, will collectively contact Mr. Purcell, who's the attorney for Ms. Funke, who's retaining the will, and find out are there beneficiaries there. Clearly there's a will. We're going to assume there's beneficiaries, otherwise it's not a good will. but we're going to find out about that. What would have happened, more likely than not, had that been done? Very well would have been covered in the 1978 will. Because as most trial judges know, particularly probate judges.
I thought nobody knew about the 78 will until much later. Is that wrong?
Oh, that's correct, Judge, but, Judge Wallace, but if the inquiry was made of Mr. Purcell, it may be very likely that the 1978 would have been discovered at that time.
How would we even know that?
It's not, the only reference in the record was, I think I asked a question, and I don't want to go outside the record, obviously, but I asked a question at one point where counsel objected, where I said it was in the possession of the guardian, and I think, and that's in the record, I think that Mr. Ogun objected to that, saying they hadn't come in, but it very well may have come to fruition. It's ultimately it did. So rather than making the argument...
That's fairly speculative, isn't it?
It's speculative, but as it turns out, it probably would have happened. Because what's important, if the will was discovered, that would be important, Judge Wallace, in your honors. But more importantly, it changes the mindset of the court, because now the court knows there was maybe a donative intent. If there is no will, or the wills, there was no, the response was not that there was a will that was invalid, and it was invalid for these reasons, or it's on stay. I'm going to discuss that in just a moment, what the real circumstance was of the will. But the practicality is that the trial court would inquire into that, probably could.
But the 1992 will, the beneficiaries were non-relatives, weren't they?
That's correct.
So what difference would it have made if the existence of the 1992 will had been disclosed to the court when these petitions were filed?
It would have indicated two things. One, there was a will of beneficiaries that the ward had taken time when she was, at least at that time, assumed to be competent, that there was a donative intent. Because the testimony, I think the testimony came in through Mr. Mitchell and his cross-examination in the courtroom, was that up until that point there was no donative intent. Now that impacts the trial court. If there's no donative intent to anybody, then that changes, there wasn't any of the testators or anybody else. That's important under the BOAC case. That's one of the...
So are you suggesting that the gifts would not have been approved? These distributions while the ward was alive would not have been approved if the 1992 will had been disclosed?
Yes, sir. And I think to say otherwise, and I mean this with all great respect, assumes that a very untenable position will be taken by the trial court. Here's why. Your Honor, there's a will out there and it names some beneficiaries. Well, the beneficiaries are A and B. And they very well may have been able to find that out. But if you assume the Appellate's position that she would have gone ahead, that Judge Glisson would have made distribution to people that were not in that will, and as I said, there probably would be an inquisition or investigation as to whether there's other wills. That other will very well may have come to fruition then, and that would have changed the course of it. But even without that, there is the mindset, which is important. There's no donative intent, now there is. Certainly, that which the trial court probably would have done nothing, or at least appoint somebody to go investigate that. But to say that the trial court would distribute what totaled $385,000 to people that were not in this will or in any other document, I think is important, because the donative intent and also whether there was a gifting to other people is important. So now, instead of having no will and no gifting issues, now there's an issue where there was somebody that she cared enough about or did a will for, and they may very well carry on to further investigation where there was another will. And it very well could have been that other will would have been discovered. It was discoverable at that time.
Well, let me ask you this, because this is something that I'm confused about and don't understand, and I couldn't get from the complaint. Let's suppose that we agree with you and we reverse. What happens then? Does the personal representative try and go back 20 years and collect this money from the donees now? Does the personal representative try to collect from Mrs. Kessler? And then since these gifts were made in order to obtain tax benefits, and if the gifts are coming back, does the estate tax return have to be amended, and the decedent now loses the the benefits of the tax planning?
The remedy would be to rescind, and that's in the wherefore clause we ask that the orders be rescinded. So you're correct in part that what happens is now we're back to the day before, the moment before the orders are entered. That makes those distributions improper or unlawful, setting up a defalcation by the guardian, who is still the guardian today. In my complaint,
But when they were made pursuant to court order.
Yes. So if the court order is now rescinded by virtue of fraud perpetrated on the court, then there is no, they're rescinded. Now we're back with no order authorizing that. What that does is put that guardian in a position where she's defalcated, and there is a bond for $100,000 upon her as guardian and also on her as personal representative, because she carried through as personal representative appointed, intestate personal representative after that, and there was a subsequent bond. So now we go back, and we're in the position where I can make a claim against the bond, and there may be a personal claim or charge against her for a surcharge now against her on that. But clearly the remedy is the bond money. Now it does talk about in here where not all the checks were cashed prior to the death of Ms. Frumke. The last checks that were asked for were $15,000 each. I think only 3 of them, and this is in the record, only 3 of them cleared prior to her death. So there was, fundamentally may have happened is now we lost the tax benefit under 1038 of the tax code, and we took money away from somebody that this warrior never intended to have. In other words, didn't go to the 92 will beneficiaries, nor to any, and that's in the record, to any of the 1978 beneficiaries. By simply answering the court, and that the court got an answer at the end when LENOIR Kessler filed to be personal representative, that's when they identified the will. They said there may be a will. Well, why did they do it then? There's good reason, because LENOIR Kessler benefited, and that's in the record, benefited to the tune of $35,000 by virtue of doing this. So that's the extrinsic fraud, the fact that the court could not have all the information which it asked. And what's important, Your Honors, is that it appeared that Judge Glisson thought this was important enough. She had seen the petitions under oath saying there's no will. She inquires directly. She inquires directly, and the affirmation was there's no will, that these are the intestate beneficiaries, and then again, according to the notes of the guardian.
I thought there was a series of different judges that approved these things. You keep talking about Judge Glisson.
Yes, the first one was Judge Valenti, followed by Judge Mills, and then Judge Glisson. And unfortunately, I think it was shortly after that that Judge Glisson passed away. That's in the record, because when Judge Sestak made his ruling, he says, I need to leave to go to her service. So, but there were 3 judges, Judge Valenti, Judge Mills, Judge Glisson, had an order. Then they came back and did a subsequent petition. She denied that petition. They did an amended petition, and then there was an amended order at the very end. That's the 4th one. And I don't know that anything got passed out on that. But the money in the record, in evidence, is the amount that was distributed, and that sort of thing. So the extrinsic evidence, I did want to reserve 5 minutes for rebuttal.
All right.
Thank you, Judge. Ms. Kessler was not candid with the court so they could make a reasoned and informed decision. We cited the cases of Dean, Payette, and Bohock. Again, Bohock is important. In that case, the judge appointed a guardian ad litem or administrator ad litem in failure to disclose to the court. I've discussed how if you stood in her shoes, probably more likely what would have happened. At the point somebody will take a look at this, and that 1978 will very well may have come back. But even if it did not, again, the mindset of the court is now there's a will out there, we'll inquire, and it goes to what would the ward have wanted. But certainly I don't think the court would have distributed these funds to the people she did, given that set of circumstances. The evidence is clear that Kessler knew about the will from 1992 until the end. She admitted it in her deposition. As a public policy, the court should deter litigants from concealing legal documents which affect judicial decisions. And just to clarify, there was no ultimate ruling in the Nevada court, Your Honors. Judge Foley had a hearing. He declared her incompetent, and under the statute, you can't take care of yourself. Instead, we'll have a further hearing to determine her capacity, or testamentary capacity. Sets it for a hearing. Judge Purcell, or Mr. Purcell, comes in and says, I'm not prepared to go forward. Judge Foley declares it's void ab initio, says the power of attorney and the will are void ab initio. That was at 9:20 and 9:30 in the morning. At 10:20, the Supreme Court comes down with a writ of prohibition, grants a writ of prohibition. Now, where some of the confusion came, I think, in the record.
All right, and Mr. Umstead, you're at your 5 minutes at this point, so you can continue or save the rest of the time. All right. All right, sir.
Good morning, Your Honor. Please, the court. My name is Jack Hoagland. I represent LENOIR Kessler. I wanted to just touch on, first of all, the matter that I thought merited an objection, even oral argument, the suggestion or the inference or the argument that somehow the trial judge applied an incorrect burden of proof was something that was never raised in the briefs. I can't go out of the record. It's something I can say that had it been raised, I would have responded to. What I can indicate, Your Honor, is obviously this is a judgment entered without findings by the trial court. We have to presume that the judge applied the correct rule of law. There's nothing to indicate that he didn't apply the correct rule of law or the correct burden of proof. He did not say in the colloquy that counsel made reference to that he would apply an enhanced burden of proof or higher burden of proof. So to that extent, I think that issue is inappropriately raised. Your Honors, this is a case where the claim is fraud, and they have the burden in this case, the plaintiff below, the appellant above, of showing that there was extrinsic fraud. And basically the fraud being that my client fraudulently failed to disclose a known will, a valid will, and tell known beneficiaries of that valid will what was going on. And that's the extrinsic part of the fraud. But there has to be fraud. Judge Bray was not only the trial judge in this particular case, he was the trial judge in the competing will contest, if you will, back in 2002 or 2003. He heard all the evidence at that trial. He heard all the evidence at this trial. He had a chance to watch my client, LENOIR, testify and determine her credibility when she said that she believed there was no will because two attorneys had told her that what the legal effect of the events, the proceedings, if you will, in Las Vegas, Nevada, meant there was no will. She looked at the judge and said, that's what I believe. And he had the right to look at her demeanor and look at all the facts and say there is no fraud. And their burden is to somehow overturn what the trial judge, experienced trial judge in this case, and having the perspective from being involved in the will contest trial, said there's no fraud. Respectfully, I don't know that they've come forward with anything where this honorable court could say, well, despite the fact that Judge Bray had a chance to watch all this, both trials, that now we're going to say there was fraud, even though implicit in his judgment is a finding that there was no fraud. But even apart from that, you have this convoluted set of facts where undisputably, this isn't just a typical thing, Your Honors, where a client says, well, my lawyer told me this, or my lawyer told me that, and I relied on that. This is a case where there was at least a finding on the minutes of the Nevada paperwork, and it appears in that jurisdiction you can appeal from minutes, not a final written order. I think I might be showing my age, but I think at one time in Florida you could appeal from minutes. I could be wrong on that, but I think that probably 50 years ago you could. But in any event, there was a ruling on the minutes. Will's void ab initio. Before this case ever walked into Florida, that's what the judge said. And there is no order in Nevada that ever says that that finding on the minutes was overturned. There is an implication that perhaps the finality of that ruling is in question because later The appellate court said the attorney that was holding that will did not have to produce it, did not have to give it up, that the court, until the testator dies, doesn't have jurisdiction to determine validity. I mean, we could certainly argue or imply maybe that the validity of Judge Foley's rulings in question, but that's something for lawyers to argue about.
Isn't it the case that this 1992 will was ultimately invalidated in Florida?
By Judge Bray, yes, Your Honor. So our point is, first of all, at the time when my client LENOIR Kessler is signing off on these gift petitions that are prepared by a lawyer, there was a good faith belief for her to say there was no will because of what had transpired in Las Vegas, and these lawyers are arguing about, is it final, is it not final, what does it mean? And ultimately, what she put in there was proven to be absolutely true because Judge Bray ultimately said there was no testamentary capacity when the 1992 will was executed in Nevada. And in fact, you know, the records we put into evidence indicates the sequence is before that will was ever filed, there was a petition for there's a petition for guardianship filed by the public guardian in Nevada saying, look, these elderly folks at that time, both Mr. Frumke and Ms. Frumke, are not able to manage their money. We fear they're being taken advantage of by the neighbors, the Paredes. That's filed on March 30, 1992. The will is done on April 10. In other words, you have a will that is being executed by the ostensible alleged ward after a guardianship is filed and in the wake of a detailed report from a psychiatrist that's attached to that petition saying these people are incompetent and that Miss Mary Frumke lacks testamentary capacity. That's the time frame. And not surprisingly, Judge Foley ruled, without ever looking at the will, because the attorney would not produce it, that the person lacked testamentary capacity, and therefore the will and the power of attorney were invalid. Judge Bray rehears it or hears it anew in Florida 10 years later, comes to the same conclusion. So at the time Ms. Kessler, my client, made the statement, signed off on the petitions in the will, that in the gift petitions, that there was no will, it was arguably true. There was at least a good faith reason to be true, or lawyers were saying it was true, and ultimately, it in fact, I guess you could say it was confirmed, or was in fact true. So their whole underpinning is there was somehow to their argument is there was a false statement made in the petitions. Well, it was arguably true at the time, and it's certainly true now. And the other part
is that your client had disclosed the existence of the 1992 will. How does that change anything?
I don't think it would have changed anything, Your Honor, because I've tried to imagine, you know, I do a little probate, I do a lot of litigation, but just say, because I'm like, okay, well, let's say that, you know, Mr. Kaltenbach, the attorney, you know, in an abundance of candor, which obviously he's got a duty to do, it's an ex parte proceeding, but say that instead of just reaching the conclusion there was no will, he put all of this information in there, and a busy probate judge is sitting there, and Mr. Kaltenbach says, well, there might be a will, but there really isn't a will, and it's been ruled invalid. We really don't even know who the beneficiaries are of that will because the attorney out there won't give it up, but we wanted you to know about it. Then the judge would say, well, who do you think the beneficiaries are? Well, Mr. Kaltenbach says to the judge, well, it's these two people that took advantage of her. Is the judge at that point going to say, I want these people here? That's going to be a game changer, that I'm going to give the property to two people who exploited her and that procured a will 10 days after a guardianship petition was filed? But the other problem is nobody knew for sure that the Paredes were even the beneficiaries of that will. In other words, under the Dean versus Buckley case that the other side is relying upon, you know, the wrong thing to do is to not disclose or not give notice of such petitions to the known beneficiary of a valid will. The thing is, nobody knew for sure who it was. The attorney out there prevailed on his petition for writ of prohibition to not give the will up. Judge Foley originally said, look, I want you to produce the will at the hearing, I want to take a look at it. Well, the attorney refused to produce it. Judge Foley basically said, based on the report, the will is invalid for lack of capacity. I don't need to see the will. The attorney still appealed the requirement, the personal order, that he give the will up. He prevailed on that. So he kept the will. Nobody had it. there's no indication that if the judge down here had ordered it up that he would have given up the will. A judge in Nevada, the highest court in Nevada, had already told the attorney that had the will that he didn't have to give it up. So we don't even know who the beneficiaries were. At the most, we would expect it. But somehow if they had gotten notice and come down here, I don't see that it changes anything. I mean, there's only two things that could have happened if the Paredes somehow showed up, that we assumed that they were the beneficiaries, sent them notice, they showed up. I would think the judge would say, folks, if you think that I'm going to let you take advantage of an elderly lady and then claim that you're entitled to gifts, you're in front of the wrong judge. The other possibility is somehow if the judge said, oh, okay, you look like lovely folks, and I'm going to give you it, that doesn't help out the Comazzi situation, because then the money would have gone to the wrong people anyway.
Or any of the recipients of the lifetime gifts beneficiaries under the 1978 will?
They were not. Now, what is of importance to us is actually two of the beneficiaries, or that took under the gift planning disbursements. One was Joseph Comazzi, the personal representative bringing the action, his mother, and the other was his grandmother. And they each got gifts and gave him small residual gifts. I mean, the true irony is that the whole claim of fraud here is that somehow if my client had given notice to the Paredes, that would have flowed over to Mr. Comazzi, and that somehow he would have found a 1978 will that nobody knew existed. And there's no proof on any of this, but the whole theory of the original complaint was, well, if notice had gone to the Paredes, somehow it would have gotten to Comazzi. It did get to Comazzi. He testified in response to my questions that he knew all about the gifting process. I'm talking about Joseph Comazzi, the current litigant, the PR. The reason he knew about it, his mother was getting gifts and he was kind of interested in it. So as the paperwork would come in, and he would read it. And he had no objection to it for two reasons. He wouldn't want to cut his mother out of the gifts, but number two, he was getting a piece of the action. He would get a small hit. Each time his mom or his grandma would get a hit, he would get a hit. So in answer to your question, no, there was no commonality, if you will, between the gift recipients and the beneficiaries under the will ultimately admitted. But there was knowledge by Mr. Comazzi of what was going on, no indication of any objection. Now, obviously, he didn't know about the 1978 will, but he knew about the process, and their whole argument is that if notice had been given to the Comazzis, it would have gotten to, if notice had been given to the Paredes, that it would have gotten to the Comazzis. Comazzi knew about it and chose not to come down. That's his uncontradicted testimony. But the idea that the Paredes would have been motivated, which the way they filed this complaint is that they had just given notice to the Paredes, they would have protected the interests of the Comazzis. We respectfully submit that's absurd. They were competing beneficiaries then, and they were competing beneficiaries in the will contest. The Paredes, the beneficiaries under the Nevada will, would have had no incentive to protect the rights of the beneficiaries under the later will. And so that whole argument falls by the wayside. And now we're coming back 20 years later, and frankly, Your Honor, I don't mean to be pandering, but that's a great point. I've been with this case. I never even thought about the concept that if we're going to roll this back and there's a recovery that Mr. Umstead hopes to get from the sureties, I guess there would have to be another amended estate tax return. I don't see another way around it, because if the gift plannings are set aside, then I think we'd have to go there. It seems we respectfully submit there has to be an end to the litigation, but certainly Judge Bray was aware of all of this, all of these facts. He saw my client. He more than anybody else would have been aware of local procedures, local tendencies. Now, obviously, he didn't take judicial notice of that, but I don't think as a judge hearing this type of case non-jury, he has to be ignorant of what's going on. There's just not a hint of fraud of the nature that would permit overturning of orders in this particular case. Mr. Umstead had made one comment that I did want to respectfully differ with. He said that if the 1992 will had been made known to the judge, then Judge Glisson, or one of the judges, would have known that the person had a donative intent, that Ms. Frumke had it in her mind that she wanted to do it. The 1992, again, was not even executed at a time where we could give significance to that, because it was 10 days after a guardianship petition was filed when she didn't have testamentary capacity. And in fact, the letter, the report from the forensic psychiatrist talks to her about this is done 4 days after the will, and this is in the record. She tells me that her husband has been in the hospital, and her neighbors, Loretta Ramos, it's incorrect, obviously she didn't even know the name of her neighbors, and her husband have been very nice to her, have taken her repeatedly to the hospital. She states that they are such kind people. She indicates, I gave them what I felt I should. They deserved it. So at that point in time, the fact that these same people are preying upon her would have no importance, I would respectfully submit, in the judge's mind, and no indicia that she had donative intent. All that would have told her is she's being exploited by people in Nevada. So that doesn't mean anything. Respectfully, also, there is no evidence. What they are trying to say is that somehow if somebody had pursued the 1992 will, that the 1978 will would have surfaced. There is absolutely no evidence. There's no witness that testified to that at all. There is not even a hint of evidence in the record. And again, even if there was some inferences, Judge Bray is the one that had the ability to sift through that and to look through the overall pattern and say, is it reasonable that somehow we would have discovered a will? And I don't believe that's pled either, and I could be wrong on that, that somehow the 78 will would have been discovered. Their theory in this complaint was that somehow if the Paradis had been put on notice, that the Paradis would somehow have protected the interest of competing will beneficiaries, which were the Comazzi people. That was the whole idea, and then it all kind of changed when the evidence showed that the Comazzi knew about it anyway, and that there was no fraud in terms of the way the petitions were drafted. I think one thing we also noted, Your Honor, and I think that Judge Bray could look at this, there is some case law cited that says that if you're going to come in and try to overturn a judgment with fraud, you need to move with reasonable diligence. Understanding things take a while, but we're at about 20 years since that first gift planning disbursement. Ms. Frumke died, I believe, in September of 1996. And understanding Mr. Comazzi did not get appointed and get the letters till 2003, but we are now here in 2014. I don't believe this case was even filed for extrinsic fraud until 2006. It got kicked twice by the clerk for non-prosecution. I do think that that is something Judge Bray could have at least considered. And because he didn't make findings, he didn't have to make findings in this type of case, any of these things could be, we would respectfully submit, and should be a reasonable basis for the judge to say, no, I can't find fraud. I can't find that it would have made a difference. I can't find that there was any attempt to do anything wrongful. The gifts would have been made anyway. And as Your Honor has pointed out, where are we going to be if we try to roll it all back? I think a judge can look at that. I mean, for example, Mr. Comazzi got money. Is he going to surcharge himself? Is he going to bring his own money back in the pot? Is he going to sue his mom? Because his mom got $40,000 or $50,000. In fact, that is a question I asked Mr. Comazzi during the trial. I said, if you get these gifts rolled back, are you going to sue your mom? No. Are you going to sue your grandma? No. Are you going to give the money you got back from them, your derivative gifts back? No. What about your sister who also got derivative gifts back? No. And then, as Your Honor has pointed out, we have the tax thing. And I think Judge Bray could consider the ramifications of all that, particularly when we're talking about an extraordinary action, really, an extraordinary equitable action to set aside duly entered orders for fraud. Thank you, Your Honors. Unless any member of the court has additional questions, I don't have anything else.
All right. Thank you, sir.
Yes.
All right, Mr. Umstead, you have 5 minutes left for rebuttal.
No harm, no foul. It's an issue here, it's fundamental due process and candor with the court. What's important in response to Mr. Hoagland's argument, let me point out to the court the evidence. Petition for appointment at page 606 of the record. Petition for appointment of plenary guardian on page 607. This is in July of 1992. In that, Ms. Kessler signs a document saying that they're including the language that there's certain litigation until certain litigation in Nevada is resolved. What's next is important. The record at 632, Judge Sestak's order, unappealed. There has been no determination of the validity of the last will and testament of Mary Frumke by any court. This is March of 1997. Now, just 5 months earlier, Ms. Kessler filed a petition to Judge Glisson asking for a distribution. That was in September of 1996. This order is 5 months later. Judge Sestak goes on in his order, says, LENOIR Kessler was aware of the existence of a will and was advised by her counsel, Mr. Mitchell, that it was improper to petition the court to make estate tax reduction gifts prior to terminating Mr. Mitchell's representation of her. Because of the estate tax reduction gifts that were made by Ms. Kessler as guardian, without those people who may be the named beneficiaries ever knowing about it, she holds an adverse or conflicting interest. Those people being the Probates, or anybody who would be virtually represented by them, and that is the extrinsic fraud. Their inability to notify Mr. Purcell, who filed 2 appeals to the Supreme Court. Had he been notified that there was a plan to distribute this estate to other people, other than what his clients, to say that he wouldn't come forward and be part of these proceedings, I think is not a tenable position. In the record at 635, the judge's ruling, Judge Sestak's ruling, which is in evidence, Judge Sestak, leading up to that order, and this is very important, Your Honors, I'm going to remove Ms. Kessler as the personal representative based upon the fact that there's a conflict of interest that she has with the estate in both operations as guardian, in that she had the very competent assistance of counsel through Mr. Mitchell, who advised her that he would not have advised her to make any type of these gifts. Later on, the court goes on to say, but at the same time, a legal representative, her attorney, is telling her there is the existence of a will. This is what the judge heard after this trial, that she was told there's the existence of a will. I don't know who the beneficiaries are in that will. I don't know what interest they may have, so please don't do that. Notice, please don't make a gift. I think that went into an order that's on appeal. At the record at 639, the court closes with, it's based on what this court perceives as a conflict of interest between what has occurred during the guardianship when there was the existence of a will that was known. Whether it's valid or not, no court has made that determination, and that there were monies that were taken out of the estate without those people who may be the named beneficiaries ever knowing about it. That is the extrinsic fraud, Your Honor. Now, going to the record in evidence at 643 is the court minutes, where Judge Glisson queries, that the record reads, the court queried of the witness if all the named beneficiaries in the petition were the beneficiaries named in the will. We don't know why she said the beneficiaries named in the will. There may have been another discussion, we don't know. But Ms. Kessler responds in the negative and advised the court that Ms. Frumke did not have a will.
Well, were the recipients of the gifts, were they what were believed to be what would have been the intestate beneficiaries? Is that how they were picked?
Some of them were intestate beneficiaries. Ms. Kessler was not in the first class of intestate beneficiaries. She was further down in the airline. I think she's the child of an intestate beneficiary. She was the child that happened to take. But it wasn't pure intestate. There was 2 family friends that were included in that were not blood relatives. I believe that. I don't think that's accurate, Judge Wallace. What's telling, Your Honors, on top of this, and I put into evidence, is Mr. Kaltenbach filed a petition to be paid. And at the record at page 702, on September 6th of September 13th of 1996, his notes reflect that he prepared a final draft of petition for disbursement of additional funds, client conference and signature, etc. Right below that, in his notes, review of Nevada file regarding status of Nevada will, unable to determine, letter to Attorney Trent. So he knows that, he sees the will, at the same time prepares a document in which the document says to the court, there's no will. And lastly, Your Honors, in the petition for administration filed by Ms. Kessler at the end, record 714, she said, the document says, there may be a will that was prepared in another state prior to guardianship counsel attempted to obtain, that must be Mr. Mitchell, to obtain it, was unsuccessful. So again, the only time she says there is no will is when query involving distribution of assets to which she was a part beneficiary. Thank you.
All right, thank you, gentlemen. That concludes the docket, and we'll be adjourned.
I think I'll retire.